It's a great pleasure indeed to introduce Chief Justice Robert French to you. It's, as you will know from the reading that you did, the Chief Justice now presides over the High Court of Australia, a court that's at the apex of the court system in Australia, which in many ways is similar to the court system as we find it here, the federal courts, the state courts. Justice French was appointed to the High Court as the Chief Justice in September 2008. He was elevated from the Federal Court of Australia, to which court he was appointed in 1986. So he's had a long judicial career, and that appointment, I think, was before the Chief Justice turned 40. So, and this, I might add, was from the beginning of a career which Australians would say he was a bit of a bush lawyer. He went out from Perth into the bush. He started up his own firm. He represented people on the land in various disputes and other legal matters. And importantly, he represented Aborigines at that time, experience that he really brought to the federal court when the federal court, as a result of the Mabo decision from the High Court, which recognised Aboriginal land rights, jurisdiction was invested in the federal court to adjudicate these land right claims by Aboriginals under the Mabo decision. It's an important jurisdiction that the federal court has had, and the Chief Justice has had long experience in that area as well as in commercial areas and particularly in trade practices, as the Australians call it, or competition practice. He has been very much involved in that over the years. We've crossed paths just lightly over the years, I think. We were trying to remember last night where it was that we had met one another, and it must have been an auspicious occasion because we couldn't remember it. But we should have actually crossed paths quite heavily. The firm that I was in Sydney was called Sly and Russell, and the successor firm, Sly and Weigel, I think it was, took over the Chief Justice's law firm, which he'd developed in Perth during that time, becoming a big national law firm. We've also crossed paths because I was on the Law Reform Commission, as Australian Law Reform Commission, as the Chief Justice was at one point, and I've had, and I still have, many friends on the Federal Court and a few on the High Court who have told me over the years what a terrific guy this Bob French is and was. And indeed, they were right. He was appointed the Chief Justice. So I just wanted to mention one thing, which I hope that you've noted, that, and we should congratulate the Chief Justice on this. Just recently, he was appointed as a companion in the General Division of the Order of Australia, which is the highest honour that Australia can give. If this were just a few years ago, he would have been Sir Robert, but not now. We don't have to be so formal as to that. I had a hat which I've left. Beth, could we grab the hat that I was supposed to give the Chief Justice in my office? Yeah, I can give it to him during the talk. But it's a fine Emory baseball cap. So we don't have a sword to doff him with, but we're going to give him this cap to keep the Australian sun off. I did want to acknowledge the co-sponsorship of Chief Justice's visit by the Halle Institute. And at the Halle Institute, Evan Goldberg has done his usual superb job. Thank you very much, Evan, for all of your organisation. At the law school, Beth, who obviously is absolutely essential, did a whole lot of great work, as did Bobby Ardia, who did a lot of the heavy lifting. So let us welcome the Chief Justice of the High Court of Australia to the podium. Chief Justice.
Thanks very much, David, for your warm welcome. It's terrific to be here. Emory Law School, of course, has a very high reputation, both nationally and internationally. And indeed, so does your Dean. I've visited Washington Law School at St. Louis on this trip, and also the School of Law at Alabama, and I keep bumping into people who say, give my regards to David Bartlett, or he's been Dean here or there or other places. So it's great to be here. What I would like to do is to talk a little bit about our Constitution and our federal arrangements, and maybe some aspects of federal jurisdiction. And finally, if I have time, just a brief mention of how one gets on without a Bill of Rights, because we don't have one in our country. I want to make it fairly brief if I can, because I'd like the chance for a bit of interaction. I think that's a much more fruitful way of doing things than just standing here as a talking head. But can I begin by just a reference to a case which I think brings up a few nice little points about our federal arrangements, which I sat on as a federal judge in 2008, in fact only a few months before I was appointed as Chief Justice. The Pope was visiting New South Wales. It was World Youth Day, which is kind of like Olympics for the Catholics. You have a whole lot of people come from all over the world for World Youth Day. And of course it's important to the state economy. All these people spend money, so these pilgrims who come to celebrate their religious affiliation with the Pope spend and live at, stay in accommodation and so forth while they're there. Anyway, the New South Wales state government was very keen to make sure that the pilgrims had a good time and that everything went smoothly, so it passed a World Youth Day Act. And under the World Youth Day Act, it conferred a power on the relevant minister of the Crown to make regulations. And one of the regulations they made was that a public official designated under the Act could direct any person to cease annoying pilgrims. Now, there was a group called the Anti-Pope Coalition who wanted to do just that. Particularly, they wanted to hand out free condoms. And they decided to take a challenge in the federal court to the validity of this state regulation. And they brought that challenge on the basis that the state regulation infringed against the implied freedom of political communication, which has been implied from our Constitution by the High Court since the 1990s, based on the provisions of our Constitution for representative democracy, members directly chosen by the people, and also for popular referendum to amend the Constitution. So they brought their claim primarily on that basis. However, I was acting Chief Justice of the Federal Court at the time, and I constituted a bench of 3 to exercise the original jurisdiction on the basis that it was an urgent matter. The Pope was arriving in about 3 or 4 days' time, and there was probably not going to be time to go through an appellate process from a single judge to a full court. So we sat a bench of 3. I sat with 2 women, Catherine Branson, who's now the President of the Human Rights Commission in Australia, and Margaret Stone, who is a member of the Federal Court. And the approach we took with this regulation was first to, before looking to the constitutional question, was to look to see whether the regulation was in fact authorised by the Act under which it was made. So in other words, although it was the federal question arising under the Constitution was that which engaged our jurisdiction, the first question to which we went was the state law question. And we looked at the authority to make regulations, And we read that authority. We looked at the width of the regulation, the concept of annoyance. I remember asking counsel, now, how wide is this notion of annoyance? You know, if I'm at a football stadium, for example, barracking for the Dockers, which is a Fremantle team from where I come from, and I'm in the middle of a bunch of Sydney Swans supporters, which had happened to me on one occasion, am I annoying them by, you know, just putting another view? And we've had much debate about the scope of annoyance. Anyway, we decided it was a very wide term. What's one person's annoyance is another person's exercise of, you know, just ordinary right to express opinions. And so we looked at the power and we said this power has to be construed according to the common law principle of legality. The common law principle of legality in Australia and in the United Kingdom is really involves a proposition that where you interpret a statute which appears to have an effect upon common law rights and freedoms, you do not interpret it as to interfere with them unless very clear words are used in the statute. This principle, incidentally, in Australia originates in a case decided in 1908 in the High Court, which quoted a passage from Maxwell on Statutes in 1904, which passage was taken from a judgment of Chief Justice Marshall in a case about bankruptcy priorities in 1805. This is just to mention we do use foreign law sometimes. So we applied this principle of legality and said this general power to make regulations should not be read in such a way, absent clear words, as to authorise a regulation which interferes with the common law right of freedom of the common law freedom of expression. And so we simply struck down the regulation on the basis that it was not authorised by the Act. Now, what I suppose that throws up is this was an example of a federal court created under our Constitution, which provides for the creation of federal courts. The court was exercising federal jurisdiction conferred upon it by a statute made under the Constitution, the Judiciary Act. Under that statute, federal courts can exercise jurisdiction in matters arising under the Constitution. That was a jurisdiction which incidentally is concurrent with that of the states. They could have gone to a state court because the state courts are also given under the Judiciary Act jurisdiction in those matters. Pretty well concurrent federal jurisdiction in most matters. There are some exceptions. We were applying a common law rule. Now, we're applying a common law rule not of the state of New South Wales, but a common law rule good for the whole of Australia. Because Australia, unlike the US, has one common law, and it has one common law because of our appellate structure. Because under Section 73 of our Constitution, the High Court hears appeals from all the courts of the final courts of the states. And so instead of the state Supreme Courts being the final appellate courts to determine what is the common law of each state, the High Court determines what is the common law of Australia. And the final point I want to make is that here we're applying a common law principle of interpretation which has had quite a significant impact in Australia in relation to just the protection of rights, even though it can be displaced by clear statutory language. So the case, which had its own interest, is also a nice illustration of a number of features of our federal jurisdiction and the way our Constitution is organised. Can I then give you a really quick whistle-stop tour? I once did this in, I think, 8 minutes for an Indonesian delegation explaining federal jurisdiction to them. They went away looking a bit bemused. I'll go further than I did with the Indonesians. I'll give you a little bit of our constitutional history, distribution of powers, and then how our federal jurisdiction is arranged. So we start at the end of the 19th century with a group of self-governing colonies in Australia. Each of their constitutions derives its legal authority from a statute passed by the UK Parliament, the Imperial Parliament, we'll call it at that time. Those colonies are worried about things happening. The French are sniffing around in Caledonia and New Caledonia and Vanuatu. The Germans are trying to colonise Papua New Guinea. In fact, the Queenslanders got so worried about it that they actually tried, as a self-governing colony, tried to themselves annex New Guinea as part of Queensland and were repudiated by the imperial authorities for doing so. So they're worried about the French and the Germans, and we're always worried about the Russians. We've got gun emplacements around the Australian coast, even down the south coast of Western Australia, to try and keep Russian invaders away. We're always worried about the Chinese, of course. So, you know, there were sort of these masses of people to our north, and there was gravitational force pulling them down towards Australia. So all of these things impel the colonies to start thinking about uniting together in some sort of federation. And they went into a drafting process involving representatives of each of the colonies, which lasted really for about 8 or 9 years. It started in 1890 and it finished effectively in 1898. And ultimately what they came up with was a draft constitution. They put that to popular referenda in each of the colonies, and it having been adopted by those popular referenda, that gave it no legal authority. They then submitted it to the British Parliament and asked, turn this into our constitution. And the British Parliament enacted a statute called the Commonwealth of Australia Constitution Act, Section 9 of which is our constitution. And so the initial legal authority for the Australian Constitution was an imperial statute. And the imperial statute has a preamble that says, whereas the people of Australia have expressed their desire, etc. So there's a sort of strand of popular sovereignty there. And there has been an argument that's developed in some dicta in the High Court, especially in the implied freedom of political communication case, which I mentioned, which suggests that perhaps the ground of authority for the Australian Constitution has shifted from the statute to popular acceptance. All right, that constitution came into effect on the 1st of January 1901. Now, at that stage, Australia was not a fully fledged nation. It was still like a large self-governing colony. It derived its legal powers from the British Parliament. The British Parliament could still actually legislate for Australia if it wanted to. Australia didn't have executive independence. That only came in 1926 in an agreement between the executive governments of Britain and the Dominions. We didn't get legislative independence from the UK in relation to the Commonwealth level until about 1942, when we adopted a statute, an imperial statute called the Statute of Westminster, and that took away the power of the British Parliament to legislate directly for the whole of Australia. The British Parliament could, however, still legislate directly for the states under something called the Colonial Laws Validity Act of 1865. So we had this bizarre situation. We had a Commonwealth which was effectively legislatively independent. We had states still kind of colonies of the UK. And that all changed in 1986 when we finally abolished all appeals to the Privy Council from the states, and the British Parliament's, in theory, its power to legislate for Australia was, as it were, renounced. Really, if you like, the full scope of Australian nationhood emerged. We are still, of course, a constitutional monarchy. The Queen of England is the Queen of Australia and appoints a Governor-General as her representative, and that Governor-General is embedded in our Constitution as the repository of part of the legislative power and also the executive power. So our legislative power is vested in the Parliament, which is the Senate, the House of Representatives, and the Governor-General. And the Governor-General signs off on legislation which is passed by those two chambers. And if the Governor-General tried to act against the advice of the Prime Minister and the ministers of the day, then the likely result is that the Governor-General would be sacked upon advice to the Queen. I mean, we have had a constitutional crisis in which the Governor-General actually sacked the Prime Minister, and that happened in 1975, but that's really a tale for another lecture. Now, the internal distribution of powers under the Constitution involves the conferring upon our Commonwealth Parliament of enumerated powers under Section 51. It's similar to the American Constitution in that respect. In fact, our Constitution was drafted initially based on the US Constitution. Inglis Clark, who was the Attorney General of Tasmania, the colony at the bottom of Australia, the little island, had been to the US. He met Oliver Wendell Holmes. They had a correspondence. He was a great admirer of American democracy, and he did his first draft based on the US Constitution, also trying to put in a Bill of Rights. He wanted equal protection, he wanted due process, and some other things. That was the equal protection and due process provisions were rejected because the states were worried about having their legislative powers fettered, and they wanted to be able to discriminate against people, especially of different races. But nevertheless, we got some guarantees: trial by jury, freedom of religion, non-discrimination against residents of different states, and so forth. And later on, an implication in terms of political freedom of political expression. Commonwealth power has been interpreted expansively by the High Court at the expense of the states, some would say. Commonwealth powers are interpreted in an expansive and plenary way, and that's happened since the engineers case in 1920, so that the mere fact that a Commonwealth power might impact upon state functions in some way or state legislative powers does not of itself mean that the exercise of that power is invalid. There's a paramountcy provision, section 109, so that Commonwealth laws which are inconsistent with a state law will prevail over the state law to the extent of and for the duration of the inconsistency. Other factors in our constitution which have contributed to the expansion of Commonwealth power include section 96, which is a financial grants provision, allows the Commonwealth to make conditional grants to the states, and those conditions can be on any topic. They don't have to be related to matters which are the subject of Commonwealth heads of power. So the Commonwealth, by making conditional grants, was able to get into things like hospitals and universities and roads and healthcare and so forth. Our external affairs power is a power for the Commonwealth Parliament to make laws with respect to external affairs. Now, what does that mean? The Commonwealth can implement treaties entered into by the executive government, perhaps on any topic. One example we were discussing was, I think, the Tasmanian Dams case, in which the Commonwealth basically blocked, under certain Commonwealth laws, the construction of a dam in an environmentally sensitive area of Tasmania, and did so in reliance upon an international environmental convention to which Australia was party. A key case I might mention in relation to this external affairs power, in which I was involved as one of the junior counsel for the Commonwealth, was Koowarta's case, and that involved the Race Discrimination Act. The Commonwealth did not have power to pass laws generally prohibiting racial discrimination. There's a race power in the Constitution, but that's for people of specific races. The Commonwealth had become, by executive agreement, a party to the Convention for the Elimination of All Forms of Race Discrimination. And then it passed an act called the Race Discrimination Act in 1975. Queensland was a state in which there was an Aboriginal population, and an Aboriginal funding group wanted to fund the acquisition of a pastoral lease, which is like a ranch, by an Aboriginal person, Mr. Koowarta. And the Queensland government had a policy that we don't favour transfer of leases of this kind into Aboriginal hands because they don't know how to work them properly. And so the minister refused to approve the transfer. Koowarta challenged the minister's decision under the Race Discrimination Act. He said this is contrary to the prohibitions against race discrimination in various forms under sections 9 and 10. Queensland countered by challenging the constitutional validity of the Act. It said the external affairs power did not run this far to allow the Commonwealth to make a law which effectively interfered with, if you like, the domestic laws and executive acts of the state. And to cut a long story short, the High Court, by I think it was a 4-3 majority, upheld the Race Discrimination Act as an implementation of the treaty, which was a valid exercise of the external affairs power. Another important area of legislative power which has affected federal balance, if you like to call it that, although it's a term which the High Court has eschewed, is the corporations power. And under the corporations power, the Commonwealth has been able to enter into, it feels like, industrial relations because most businesses are carried on by corporations. Even universities have been caught by it. We had a case a few years ago in which a university academic from Western Australia challenged an enterprise agreement which his university had entered into, binding all staff, even if they hadn't personally signed off on it, pursuant to the provisions of the Workplace Relations Act. And he held that that act, which is a Commonwealth Act applying to trading and financial corporations, didn't apply to universities. So we had to look at what the University of Western Australia did. This is in a federal court context, and looked at their financial activities, and of course all the universities these days are into commercial activities of one kind or another. So we had little difficulty in concluding that the university was a financial corporation or a trading corporation and was subject to this power. So there are just a number of areas in which there has been quite an extension of Commonwealth power over the history of the Federation. We are seeing an increase too in cooperative federalism, which is a kind of, in a sense, a de facto centralisation, because there are a number of areas of regulation where the Commonwealth can't cover the entire field, and where it has to do so pursuant to agreements with the state. So you'll find that regulation of national infrastructure in things like, say, access to essential facilities, which is under our competition law, require complementary laws to be made by the participating states, a regulator to be set up, which is given functions under state law as well as under Commonwealth law. At the present time, the Attorney General of the Commonwealth is trying to herd the cats of the states to agree upon a common framework for national regulation of the legal profession, so that a legal professional admitted in under a national scheme is a legal professional for the whole of Australia. At the moment, if you get admitted in one state, you get admitted in another state almost automatically, but there's no national regulation. And so they're trying to do that by having each state enact a law. One of the states sets up the regulator and the other states give the regulator power. And then the regulator has these, the great debate is the executive going to appoint the members of this regulator, or is the profession and the judiciary going to be involved in it, and how does that affect the independence of the legal profession, and so forth. So some of the states are coming on board, others aren't. But cooperative federalism has been a big feature of the Australian Federation in the last 20 years or so. Okay, so finally, federal judicial power. Under our Chapter 3 of our Constitution, the equivalent of your Article 3, federal judicial power resides in the High Court. It also resides in such courts as are created by the Parliament of the Commonwealth, and also on such other courts with which the Commonwealth invests with federal jurisdiction. This last bit was called rather grandly by one of our former Chief Justices, Sir Owen Dixon, the autochthonous expedient. In other words, we thought of it ourselves. The idea was that whereas, as I understand it, there is no express provision for legislative conferring of federal jurisdiction on your state courts, although under the state constitutions apparently they are seen as competent to exercise, deal with federal questions. There is this specific provision under which state courts can be given federal jurisdiction, and the idea was that this was a cost-saving measure. We didn't want to set up a whole system of circuit courts and things, and the state courts were regarded as quite competent at the time of federation. They were already in place. There was a Supreme Court in each state and generally well respected. So we end up with this system where we have a Judiciary Act, which was passed in 1903. The Judiciary Act provided for state courts to exercise all kinds of federal jurisdiction, matters arising under the Constitution, matters matters arising under laws of the Commonwealth, and so forth, quite a number of things. And for many years, that was the way in which federal questions were decided in Australia, by state courts. We had the odd specialist federal court. There was a federal bankruptcy court for a while, but it wasn't until 1976 that we got serious about a federal court system. And in 1976, the Federal Court of Australia was created. And that kind of paralleled the creation of some important national legislation, like our first Competition Law Act, big Competition Law Act. There'd been a thing we'd had way back in the 1900s, but nothing had been terribly effective until then. So we had a Competition Law Act, we had judicial review packages in relation to, legislative packages in relation to Commonwealth decisions. And I think the government of the day decided it was time to bring in a federal court to deal with these issues of federal law. And so the Federal Court of Australia was set up. Initially it had a narrow band of statutory jurisdictions. Over the years those expanded. Now, associated with the creation of the Federal Court, and its was the creation of the Federal Family Court, which was also a national court to administer the Family Law Act. The Federal Court ultimately has jurisdiction in federal matters which is mainly concurrent with those of the states. There are some areas where it would be exclusive, but for the most part it's concurrent. And it doesn't just deal with federal questions. Now, our jurisdiction is conferred, federal jurisdiction is conferred in terms of matters. So you get jurisdiction in a matter arising under the Constitution. The equivalent expression, I think, in your Article 3 is cases and controversies. And one of the ideas that was imported from the US, I think, is called here the pendant jurisdiction. We call it the accrued jurisdiction. So if I had a case in the federal court which involved a claim of misleading or deceptive conduct under our Trade Practices Act, which is a federal prohibition actionable with a damages remedy by any person, then I could at the same time deal with a contractual misrepresentation, maybe a negligent misstatement, or even a deceit claim under it, and maybe even a claim arising under a state statute. So the federal court got a kind of very general accrued jurisdiction, and so became almost a bit like a court of general jurisdiction. Now, what are the implications of our Chapter 3 arrangements with federal and state courts exercising federal jurisdiction, and a high court which is exercising appellate jurisdiction from everybody? If I list them briefly, we have what you might call a national integrated judiciary, even though the state systems are legislatively and constitutionally separate from the federal. We have the single appellate jurisdiction, and associated with that, as I mentioned, one common law for the whole of Australia. We have, of course, under Chapter 3, a separation of powers. There's quite a sharp separation of powers between the judiciary on the one hand and the legislature and executive on the other at federal level. It doesn't apply at state level to the same extent. As a result of that, we have a doctrine of incompatibility. A federal judge can't be asked to do something, can't do something which is incompatible with federal judicial office. And there are certain types of administrative function with a political flavour which have been held to fall foul of that doctrine. We attempted to have a cross-vesting scheme under which the federal courts could be given jurisdiction under state law and the state courts general jurisdiction under federal law, with transfers happening between them. The federal to state cross-vesting was okay, but the High Court struck down the notion that state parliaments could make laws conferring jurisdiction on federal courts, even if that were done with the consent of the federal parliament. We have developed a doctrine which enables control of judicial standards in relation to state courts. This is the Cable Doctrine. Because the state courts are repositories of federal jurisdiction under our Constitution, they have to be fit repositories. They have to retain the essential characteristics of courts. So we have said that state parliaments cannot confer upon state courts functions which are repugnant to the judicial function or incompatible with their status as repositories of federal jurisdiction. And on that basis, for example, we struck down a provision of a state law recently, which was directed at bikie gangs, under which the Attorney General of the state of South Australia could make a declaration about an organisation under his Act, purely administrative process. And then once that administrative declaration had been made based on all kinds of secret evidence and so forth, the Commissioner of Police could approach the State Magistrates Court, say, Mr. X is a member of that declared organisation, I want a control order, and the law said that the court must make a control order in that case. Now, all that the court needed to determine in order to enliven the obligation imposed upon it to make a control order, which affected rights of association and so forth, was that there was a declared organisation, this person was a member of it. The notion of membership was very broad, including people who are treated by the organisation as members, even if they no longer regarded themselves as such. The impact on the right of association covered the association with a whole range of people, not just other members, and association was very broadly defined as including anything beyond 6 text or email exchanges in the course of 12 months. Now, what we said was that this legislation involved an enlistment by the executive of the judicial function to give a kind of judicial appearance, if you like, to what was essentially an executive action. It was inconsistent with the essential characteristics of the court, and thus struck down under this doctrine, this Chapter 3 doctrine. So the Finks Motorcycle Club had a win, and saw television footage of these tattooed characters in leathers toasting, I think, the High Court in a bar somewhere in Adelaide. We have one reserved from New South Wales involving the Hells Angels. And there, the question is not about the Attorney General making a declaration which effectively binds the court. The question is using judges as administrative officials to make the declaration, and designated judges selected by the Attorney General. The question is that a function conferred on a judge of the state court which is so incompatible with the judicial function of the state court that it reflects upon the fitness of the state court to be a repository of federal jurisdiction? Quite an important doctrine, and for a while people thought it was a bit of a dormant doctrine, but it's been revived in the last couple of years or so. The next consequence was that the states cannot abolish the Supreme Courts. The Supreme Courts at least have to remain in order to provide the vehicles for, I mean, they can rearrange things internally as they like, but they can't abolish the Supreme Courts. Because the Supreme Courts are the final point from which you get an appeal under Section 73 of our Constitution to the High Court, you can't create islands of lawlessness within a state. In other words, you cannot prevent by state law a Supreme Court from exercising supervisory jurisdiction over decision-making bodies or tribunals within the state. So in New South Wales they had a specialist tribunal, the Industrial Relations Court, not able to be reviewed for jurisdictional error in the Supreme Court. We said no, that can't stand. The Supreme Court has to have that minimum requirement of supervisory jurisdiction because that's part of the national scheme. That was the Kirk case. In the context of human rights, we've had a lot of debate about whether we should have a Human Rights Act in Australia, and this has raised a question about judicial function, because one of the things our court decided a long time ago was we couldn't issue advisory opinions. The things which defined our jurisdiction were defined by reference to matters, that is, disputes. So an advisory opinion on a law really didn't fall into that category. The model of human rights bill, which was being discussed at one stage, involved the British model, which is you have a declaration of rights, then those rights cannot, of course, invalidate other legislation because it's only a legislative model. Those rights are used as an interpretive rule for other statutes. And if a statute cannot be interpreted consistently with one of the declared rights, then the court makes a declaration of inconsistency, which then has to be tabled in Parliament. So it's a political consequence. And so one of the arguments was that if such a federal statute were created in Australia, it wouldn't be valid because the declaration of incompatibility would be an advisory opinion. Now, I don't express any view on that, but that's a live issue. Finally, we don't have, as I said, a Bill of Rights. We have a number of guarantees in our Constitution, trial by jury. The rule of law is supported very strongly by the original jurisdiction given to the High Court under Section 75(5) to entertain applications in its original jurisdiction in matters involving claims for mandamus, prohibition or injunction against officers of the Commonwealth. That was inspired by the fact that Mr. Inglis Clark, who had read Marbury and Madison when most of the other delegates hadn't, spotted that Marbury and Madison, as well as being authority for the proposition that the court could strike down laws, judicially review legislation, was also authority for the proposition the American Constitution didn't authorise the conferring of original jurisdiction to review Commonwealth, at least federal executive decisions. And he thought we need that in Australia. And there was an interesting exchange of telegrams between him from Tasmania and the leader of the Australian delegates in their convention drafting process. And Barton, who later became our first Prime Minister, sent him a telegram saying, look, you might have a good point. Nobody here seems to have read Marbury and Madison, but we think it might be something we should do. So in the debate about whether we should have this Section 75(5), Barton famously said, well, it can't do any harm and it may protect us from a great evil. And it has, in fact, had a very significant impact because being a constitutional jurisdiction, it cannot be taken away by ouster or privative clauses, even in sensitive areas like asylum seekers and so forth. We have the religion guarantee against establishment of religion or against prohibiting freedom of religion. We've got a challenge pending under that provision soon in our court. It's a challenge to federal funding for school chaplains, school ministers, so we'll see what happens with that. Section 117 prohibits discrimination in one state against the residents of another. We have the implied freedom of political communication and, of course, those common law principles of interpretation, which I've already mentioned, which are quite important. So, very briefly, that's where we are. That's the whistle-stop tour of the Australian Constitution, federal jurisdiction, life, the universe, and everything. So, thank you.
Time for questions there, Charlie. That was a wonderful whistle-stop tour. One issue you didn't address was constitutional amendment.
Yep.
Can you do that for just a moment?
Go to the microphone.
Yeah. Okay. Could you address the issue of constitutional amendment in Australia for just a moment?
Yeah, constitutional amendment is provided for under section 1 to 8 of our constitution, and it requires a bill for a proposed amendment to be passed through the Commonwealth Parliament, and then for a popular referendum you have to have a majority of electors in a majority of states. And it's been very, very difficult for amendments to succeed. I think we've had 48 referenda and only 7 amendments got up. One of them, which got up with considerable enthusiasm, was to cut the retiring age of judges from life appointments down to age 70, for federal judges, that is. So that's entrenched. Another one which got up was, in the context of your debates about healthcare, was a provision authorising the Commonwealth to make laws with respect to the provision of medical and dental services and so forth, but not so as to affect any form of civil conscription. We had a case about that last year, and that was to avoid laws which might try to nationalise the medical or dental professions. We had a referendum about the race power, which got up in 1967. That was quite an important one. There's a power under the Constitution for the Commonwealth to make laws with respect to, special laws with respect to people of any race, which the Parliament deems it necessary to make. Now, when that was first passed, it was a discriminatory law, a discriminatory provision, and it excluded people of the Aboriginal race, not in order to protect them from discriminatory laws made by the Commonwealth, but in order to let the states discriminate against them in their own particular ways. And there was a long campaign to provide, to authorise the Commonwealth to have legislative power in respect of Aborigines, because it's a national issue. And in 1967, a referendum took out that exclusion. So the race power then extended to Aboriginal people. And things like the Native Title Act were made under that. The problem of it was, of course, you had a hybrid, something devised, if you like, in a role in a context where it was going to be not beneficial to people of particular races, and then a referendum which was plainly beneficial in its purpose, and we're still working through that problem.
Australia is famously bereft of a Bill of Rights. At least that's the story. but I'm not clear after listening to your talk to what extent that really is true. It's true that the South African Constitution has a section called the Bill of Rights. And as you know, the Canadian Constitution has the section of the Constitution called the Charter of Rights and Freedoms. But unless I misunderstood you, and perhaps I did, Australia has a Bill of Rights. It's just that they're not all collected in the same location in the Constitution. And if I'm right about that, then I wonder, is the argument about whether Australia should have a Bill of Rights, or is the argument about whether certain rights that are not a part of the Australian Bill of Rights should now be added to the Constitution as well?
Yep. Well, nobody in Australia calls for the Bill of Rights in the Constitution, but undoubtedly you're right. There's a collection of rights and freedoms, although of somewhat limited scope. The argument in Australia, the term Bill of Rights has acquired, I think, a bit of political baggage, of course. And wherever it's raised, whether we're talking about a constitutional Bill of Rights, which is just off the political horizon at the moment, or a statutory Bill of Rights, which is what has been talked about, the argument has been that the creation of justiciable, broadly stated rights, involves a transfer of what is seen as essentially political power to, quote, the unelected judiciary, unquote. And because you have, as you know, where you have statements of rights, there are proportionality questions arise, there are questions of balancing, conflicting, social. You're talking about freedom of expression, freedom of religion, how these things have tensions. the notion that the judges should be involved in resolving those tensions and effectively stating principles of law for applying to the whole community is something which has been at the centre of that debate, and it's really a kind of democratic legitimacy argument.
But perhaps I didn't misunderstand you. Don't you do that already when you say that already non-establishment is protected, freedom of religion?
Oh, in those areas, yeah, yep, that's right. Yeah, that happens there. That's right. It's not entirely rational, but you know, your friend James Allen from Queensland University has written very trenchantly about this in opposition to a recent attempt by the federal government to introduce, or to at least have a national consultation about a statutory charter of some kind.
So perhaps it's a matter of emphasis in the sense that some fear that if you actually do what South Africa has done and Canada has done, it will encourage the judges to roam more broadly and aggressively?
That seems to be the thought, and that the wrong people will get up. You know, as usual, it's the thought is that it'll benefit criminals and that kind of. So they're the sorts of. Somebody in England, I think their Attorney General a while ago, maybe under the previous government, was denouncing the Human Rights Act and saying some terrible decisions had been made under it, because those are then sort of engaged in the Australian debate. Personally, obviously I'm not taking a public position on it, because if such a statutory charter came in, we might have a constitutional debate about it, along the lines I mentioned about, is it sort of setting up advisory opinion things. But it seems to me, first of all, that we have a fairly good protective regime, even using those common law rules of interpretation that I have mentioned. Importantly, there's a culture which is generally supportive of the notion of, you know, not too much government interference. It tends to break down a little bit in the areas of what one might call the law and order debate, and sometimes we've had elections at state level which are really sort of law and order auctions, and nobody seems to lose votes by promising more stringent approaches to law enforcement, even though they might infringe upon freedoms.
Thank you. It just strikes me that there are differences between the U.S. and the Australian system, one of which just the idea of concurrent jurisdiction. Here, of course, the federal government doesn't have to vest the state courts with authority, and the question becomes, if there is concurrent jurisdiction, is there an obligation on the part of the state courts to undertake jurisdiction, which doesn't sound like it would be an issue in Australia. But I guess what I would like to ask you about particularly is this idea of the state courts being fit repositories for federal jurisdiction. And I guess I'm wondering exactly how you measure that. So in this country,
qualitatively,
you know, state courts can vary quite a bit from federal courts, both in terms of how the judges are selected, how long they serve, but also you mentioned advisory opinions. Some state courts can issue advisory opinions, the federal system can't. So I wonder whether, how far, I don't know if you can speak to what metric you would use to define what a proper repository for federal authority would be.
Well, there are sort of principles in tension. There's, in fact, I wrote a bit about this in our judgment in my own judgment in Totani, which is the Bikie case, because there were statements in the early days of the Federation that the federal Parliament must take the state courts as it finds them. In other words, there is flexibility in terms of organisational arrangement and structures and so forth. But then there is this constraint. Now, the sorts of things you might look for, I suppose, and using the language which was used in Totani in the case before it called International Finance Trust, are things which deprive a state court of an essential characteristic. In the International Finance Trust, it was the law effectively in relation to interim orders for freezing funds which were suspected to be the product of crime or criminal activity. There was a provision for the state crime commission to approach the Supreme Court for an ex parte order, and then as we construed it, the legislation required the state court to make that order ex parte. Now, of course, we're all familiar with ex parte orders being made, ex parte freezing orders being made. but the court always has a discretion in the ordinary course to decide whether procedural fairness requires that it call in the other party immediately, as distinct from giving them a chance to set aside later, or whether the imperatives of the case justify the ex parte order at the first instance. Here the state court was being deprived of its opportunity to control procedural fairness, which is a pretty important attribute of courts. And so we struck it down. I struck it down on that basis alone. My colleagues in the majority struck it down on the basis that the setting aside process was too convoluted and distant in time to justify what had happened. So essential characteristic courts, so you look to procedural fairness, impacts on that, basically telling a court how to exercise its function, executive intrusion on the judicial function of the court. Effectively what happened, if you like, in the Totani case, or otherwise requiring a court to do something which is really incompatible with its function. The very first case under which this doctrine was developed was Cable's case in New South Wales in 1992. There was a dangerous prisoner, a man called Gregory Cable. He was in prison, he was serving a finite term. He'd apparently written letters saying he was going to do awful things when he got out. So the state passed a law calling the Community Protection Dangerous Prisoners Act or something, and it said the state may apply to the court for an order that the term of imprisonment of any prisoner who is considered to be dangerous may be extended. And by the way, this act only applies to Gregory Wayne Cable. And that was struck down as, in fact, even though informed discretionary, really a direction, authorising a direction by the executive to the state court as to how to deal with one particular person. And that was actually the genesis of this doctrine.
First, thanks so much for being here. And in your talk and in your paper, you talked about cooperative federalism. You talk about cooperative federalism, and you said that cooperative federalism structures have really arisen and become more prominent in the last 20 years. I was curious, one, why this has happened in the last 20 years, and then second, have you encountered in Australia what we've encountered here, which is the use of the courts to try to combat the centralizing tendency of growing centralization of authority?
As to the first question, I think what's happened is we've had the institutional arrangements set up. There's been a Council of Australian Governments, probably been a bit more than 20 years actually, in which the premiers all meet together with the Prime Minister and they discuss matters of common interest. Usually it's dominated by arguments about Commonwealth funding of states. But there have been more and more areas in which we have, under that broad COAG umbrella, ministerial councils of ministers of states and Commonwealth with overlapping responsibilities. They come together and they discuss matters of common concern. And there have been a number of areas, in fact there's a whole list on the COAG agenda of subject matter areas where it's been thought desirable to go for national regulation. Now, corporations was perhaps one of the earliest. So you would have, back in the 60s when I studied law, we had what were called Uniform Companies Acts. Originally, each of the states had its own Companies Act based on the English Act of 1862 or whenever. Then in 1961, they all agreed that they would use the same Companies Act. And it was called the Uniform. And then the little variations crept in and you end up getting differences. Then we started to get a more formal agreement that what would happen is somebody would pass an act and the others would all adopt the same act, and the Commonwealth did that. We had a scheme, I think it was in 1981, the Uniform Companies Code, and then the Commonwealth actually tried to enter the field under the, I think it was under a Labor government, tried to enter the field and actually make a law which purported to cover all corporations law just under a unilateral federal law. That fell over for a reason which might amuse some of you. We have the power to make laws with respect to corporations is the power to make laws with respect to trading and financial corporations formed within Australia. And the word formed caused it to fall over because it meant you could regulate existing corporations but you couldn't control their incorporation. And so that was struck down, and in order to get a comprehensive Corporations Act, corporations law, they went back to the cooperative model. The Commonwealth passed a law which the other states adopted. Now this all involved, this then intersected with the cross-vesting debate, because under the corporations law both federal and state courts were to exercise jurisdiction with respect to corporations, but that meant giving the federal court jurisdiction under the model state laws. And that was knocked out when the cross-vesting case was decided. And what happened after that is the states actually referred power to the Commonwealth, which they can do under the Constitution, under 5137, to make a law, a comprehensive corporations law. The Commonwealth made that, and that became, of course, a federal law, so there was no jurisdictional problem. So that was, if you like, a leading example of cooperative federalism, but it extended into other areas of regulation, particularly multi-state control of, for example, gas pipelines and electricity markets. You had to have some way of, you couldn't quarantine the electricity market of Victoria and New South Wales and South Australia from each other. So there was created a national energy regulator, and then South Australia passed the first law, creating a code about pricing and access and all the rest of it, and the other states adopted that law, and they all conferred powers on a federal body. There were some complications because it had to be supported by Commonwealth power as well. So there's been an explosion of these areas. Road transport's been another area, and all in the recognition of the fact that we increasingly have a national economy, and we're out there in a very competitive global environment, and we really have to be able to operate as efficiently as possible. And there's a lot still on the agenda, ports and railways and all sorts of things. So they're the kind of imperatives that have driven that. So far as attacks on the exercise of central power are concerned, well, you get challenges, obviously, from time to time. The most recent major challenge we had was on the Commonwealth spending power. This was the global financial crisis. Everybody's going to hell in a handbasket. The Australian government, thanks to some American banks, I think, the Australian government decides that it needs to stimulate the economy. So fiscal stimulus package is devised. This is an internationally recognised measure. They've all talked about it at international conferences in the context of the GFC. And so the Australian Parliament passes a thing called the Tax Bonus Act, under which every taxpayer in Australia gets a cheque. Okay, and they get $900 down to $200 depending on how much they earn and how much tax they pay. And so they're supposed to go out and buy flat screen televisions or other things, and so keep us all afloat. And there's a law academic, would you believe, a Mr. Pape, who says, I don't want this money. And what's more, this is beyond the spending power of the Commonwealth, and it infringes on my notion of federalism. If they were to do this properly, they should have done it through a conditional grant to the states under 96, and the states could then pay it to everybody in the state, or they could give a tax credit. This idea of direct payment by the Commonwealth is wrong. So he came to court, and of course it was all had to be dealt with very urgently. And the Commonwealth came along, but Solicitor General, the states all intervened. And in the end, what we held was that it was valid. We only did so by a sort of 4-3 majority. And the majority held that it was valid on the basis that the executive, under the executive power in section 61 of the Constitution, which mirrors your Article 2, was entitled to form the view that there was a financial problem affecting the whole country and requiring a quick response, which only the Commonwealth really had the capacity to marshal in the time frame that was necessary for it to be effective. And we had a lot of agreed facts, I might say, underpinning this. And that the Parliament could, under the incidental power, section 5139, pass laws incidental to the exercise of any power, and that the Tax Bonus Act was a legitimate exercise of that incidental power in relation to the executive determination of the power to make payments. So Mr. Pape lost the battle, but he might have won a war, because we did say, and this is the Commonwealth's main argument, we've got power to spend because section 81 of the Constitution says that all revenues or money raised or received by the executive government of the Commonwealth shall be formed one consolidated revenue fund to be appropriated for the purposes of the Commonwealth in the manner and subject to the charges and liabilities imposed by this Constitution. They said the purposes of the Commonwealth, we can do it under that. Now, there'd been a long-standing assumption that that was actually a source of substantive power. And in the end, what we said was, no, it isn't a source of substantive power. That just forms part of a scheme setting up the conditions and controls upon expenditure, rooted in the whole notion that you had to have appropriation by the Parliament of monies before they could be expended by the executive. And so it set up necessary conditions for expenditure, but not substantive power. And you had to find the substantive power somewhere else in the Constitution. In our case, we found it in Section 61, coupled with the incidental power. So Mr. Pape lost, but he was pretty happy and went around making nice speeches about us, which, although I characterised him as a man who tried to bite the hand that tried to feed him, which
by your description of the cooperative federalism in the corporate law area, which is the exact opposite of what we have in the United States, which is more of a competitive federalism, where each state tries to adopt the most attractive corporation statute it can and attract incorporations from all over the country that way. And as a result, we have a variety of laws and I think a dynamic system where change occurs in one state, other states look at it and say, well, that seems like a good idea, or we can do better. And so we've been quite comfortable with this competitive system. What drove the change to unification of corporate law in Australia?
Well, I suppose one very significant difference is we're about 22 million people, so we're the size of one of your states, that's New York. And I don't know that necessarily, I mean, there have been arguments, I know, within the states with respect to Delaware, for example, about race to the bottom type issues, but generally it was, it's really, I think, and I'm not a political scientist, so I'm making this statement in an impressionistic way. I think it's a kind of expression of the notion that we are really a small national market competing in a global economic environment, and that we can't afford to have transaction costs associated with differences in rules and regulations for our companies operating within our domestic market. In other words, they should be able to operate anywhere in Australia under the same set of rules. That's, I think, the general philosophy.
With Australia federal common law with the United States. And I had just some general questions about Australian common law. The first one is, what is the percentage of the docket for your court, for example, that's dealing with common law issues versus other things? And then the second question is, do you see, or have you experienced in the last decades, is there a sort of competition between Parliament and the judiciary over that common law, more statutory incursions, for example?
Yeah. Look, I'd have to go back and look at the cases, but I would think a lot of the cases that we have, putting aside the constitutional cases, will involve, there'll be cases involving statutes, and then there'll be cases involving common law questions. Maybe we would, if we had, say, 59 cases last year, maybe 10 or 11 or 12, something like that, might have involved common law questions. Very often the common law questions, however, are entangled with statute questions. And that leads me into your second issue. In relation, for example, to personal injuries and common law claims to negligence and so forth, there's been a great concern in recent times about award levels and the stability of insurance companies and so forth. There was a big report done by Justice David Ip in New South Wales about all of that, and that led to a civil liability act being introduced in New South Wales, which actually not only which kind of codifies aspects of foreseeability and reasonableness and so forth, and remoteness of damage. And so you have the common law rules being as it were, affected, moderated, qualified by statute. Now, a number of the other states have done that. Going to the more general aspect of the question you asked, that is quite a common phenomenon in Australia, something we don't have any problem with, obviously, and it's not seen as a question of Parliament competing with the judiciary. The supremacy of Parliament means that they can basically alter the common law subject to constitutional limits as they see fit, and there's been a lot of that has happened. But we still have an awful lot of common law stuff. We had a number of torts decisions in recent time. I know that's an area of your interest, mainly about, I think a couple of them about the responsibilities of pub owners, hotel owners to their clients who might get intoxicated and go out and drive a motorbike or something and write themselves off. And should they be or providing security for their customers? Somebody goes wild in a tavern and shoots a couple of other people. What's the liability of the tavern keeper in that respect? So we've had a number of those pure common law cases. We always have an eye cocked to see whether the Civil Liability Act has an impact in the particular case, because it might not.
Can I ask one last question, perhaps, which is really the selection of judges for the High Court, and the extent to which that may or may not have become more politicised over the years, or whether it's still very much, as I remember it, which was really a selection of mainly from Melbourne or Sydney, but you're one of the two Western Australians.
The third, actually.
The third.
Mm.
Sandgropers, as they'll call it, East Western Australia. Is this changed? Is it more politically fraught now than it ever has been?
Well, if it helps you to get an indication, my first approach from our Commonwealth Attorney General, I still remember, it was 28th of July 2008. My mobile phone sort of made a little bleep and a text message appeared saying, could you please nominate a time at which the Attorney General could ring you, from his Chief of Staff. So my first approach was by way of text, and then there was a phone call that followed, and then the matter simply went into a cabinet meeting, and the cabinet, I think there'd been a lot of stuff happening within the cabinet beforehand, but the cabinet then made a decision that I would be appointed, and then two members of the cabinet comprising the Executive Council advised the Governor-General to sign my commission as Chief Justice. So that was how easy it was in a sense. In fact, what's happened with federal appointments in Australia, they were very much lacking any transparency, as most of the state court appointments also were, but there's been an opening up of the process that people now call for nominations, at least in the state levels and for the federal court. And at the federal court level, there's a panel that vets the nominations and then prepares a shortlist which goes to the Attorney General, and then what you might call the small p political process takes over. With respect to the High Court, under the Judiciary Act, there is a statutory obligation on the Attorney General to consult with the Attorneys General of the states, but that's as far as the statutory obligation goes. This Attorney General has extended his consultation. He consults with the Chief Justices of the states, the Presidents of the Law Societies and the Bar Associations, and the women lawyers, the Deans of Law Schools. I don't know where I gather that here, yes, and also Legal Aid Commission. So there's a fairly wide-ranging thing, and then in my case I understood that they achieved a list of 24, and then that went into the sort of rather less than transparent processes of consideration within the executive arm of government. And out popped the name at the as the sort of like coming out of a black box. How many people on the court? 7, 4 men, 3 women.
Well, I think we'll all agree the result was a wonderful one. So,
thank you.